that already. I am a licensed attorney or lawyer, whatever term you want to use, in Washington State, USA, where we do have legal assisted suicide, and in the fine print, our bill and all of the Oregon-style bills also allow euthanasia, and that's because there is no requirement of self-administration. Oregon's law doesn't even use the word self-administer. That's propaganda. And Washington's law says may self-administer. And then the big umbrella is it's considered part of medicine. Well, who administers medicine? Normally, some of you out there have children. Have you ever administered medicine to your child? Okay, well that's the normal way to administer medication, is someone else can give it to you. So unless there's a clear prohibition from someone else giving it to you, the way I read the law, it already allows euthanasia. It's just sold as assisted suicide. Now, Alex and I were having a little discussion, well, should we be so clear about that? And I think we should, and let people know as they're voting for these bills, like in New Jersey or wherever's next, that this already has euthanasia hiding in it. And don't think you're just passing a limited law that's voluntary, because you're not. So that was supposed to be my introductory line, but I started talking. But I do that. I don't stay on task very well. So I'm also president of Choices Illusion. The reason for the name is whose choice will it be? Your choice or the choice of someone else? Under the Oregon and Washington laws, the easiest thing to see is there's no oversight required at the death. Two people can be there. One leaves alive, one leaves dead. What happened? And then the death certificate will say a natural death, which allows, so what if the person got off? So I'm really, this is not quite the right height, I'm sorry. Okay, so Choices Illusion, the scope is international. Didn't really start out that way. I've done some, since I'm in Canada today, I have done substantial work in Canada, more so a few years ago. I was actually allowed to specially appear in the LeBlanc case, which was the equivalent of, is that better? Oh boy, then I can't see, that's the problem. So, are we going to hear me or do I get to see? Okay. Anyway, so I was involved in the LeBlanc case, which was like Carter moving up, and then the plaintiff died, so that was the end of that case. I have worked on Carter, and I do have a few things to say about it. I also wrote an expert witness affidavit for a South African case. The client gave my affidavit credit for their winning the case. I've appeared in, I think, 20 states, some of them repeats. I know a lot about how the laws work, and part of the reason we've been losing, and I would really urge all of you, especially with organizations, we need attorneys who are highly trained in statutory interpretation. So I personally worked for the courts, and I also worked for the U.S. Department of Justice, and I got a lot of training in how to read a statute and the different rules that apply. So even if it looks like it says one thing, because of something else in the bill or the type of bill it is, it will mean something else. And so that's what's been missing. We should have never lost Oregon. Nobody knows, everyone still says it requires self-administration in Oregon. And I would invite you to all do a word search on that statute. It's not there. It's propaganda. Okay. So Choice Illusion is www.choiceillusion.org, and you already have my newsletter out there that has the links. I would encourage you to donate to my organization as well as to Alex's organization or anyone else that's appeared here today. We all need help. So I've kind of prepared this as a pep talk. I thought it might be appropriate because things might seem bleak. I'm going to talk about the Carter case, which is, from my perspective, kind of a BS case. The logic is really goofy, and I think that if you've got, I didn't know about that 3-year, you can challenge it, or that might be an opportunity, not officially to challenge it, but at least it's a deadline, that might be a good time to launch a lawsuit, talking about BS. We have a hospice bill in the US that's really a euthanasia bill, or almost a euthanasia bill. And hopefully I'm going to talk about how to argue in Oregon and Washington State. So these are my notes, which I'm not being very good at following here. Because I got like a tennis ball in front of me. Okay, so I'm going to start out some good news. Good news, this year, Utah, the state of Utah, the US, passed a new law outlining, it's a felony to assisted suicide in Utah. So that passed this year. Last year, the state of Alabama in the US passed an act banning assisted suicide. Okay? And 2 years ago, the state of New Mexico, in their court decision, overturned legal assisted suicide in New Mexico. Assisted suicide is no longer legal in New Mexico. Now, they do have a bill pending that is kind of dangerous and might pass, but I'm just trying to let you know, there's movement both ways. There's hope, even in Canada. You just have to keep trying, okay? So, let's see. I'm sorry, I went upstairs and took a nap instead of reading this. Okay, so, I just want to... Okay, another thing about the lawyer situation is people like my father, my parents, donated to Seattle University, which is a Catholic university. Other Catholics have donated to, say, Loyola or some of these other universities, so that there would be lawyers that could represent Catholic viewpoints, including opposition to things like assisted suicide, euthanasia. Well, those schools have been taken over. Compassionate Choices legal director started teaching at Seattle University like 20, 30 years ago. Their current lobbyist teaches a course on end-of-life ethics. And if you donate to those schools, call up whoever's in charge and say you're not going to donate anymore, and tell other people not to donate until they get rid of those lobbyists. Because that's part of the problem. They come in with experts. They've been doing this for years. Their points are so polished. And then what have they got? I might come in, I'm a volunteer. It's, there's a reason we're kind of losing. I mean, we lost in Oregon. We should have never lost in Oregon. There was no self-administration. And that was their big talking point. It was an initiative. So they couldn't change the language. They couldn't amend it. It was either you take the whole thing. Anyway, that can be a broken record. But all right, let's see. So I also want to talk about, part of my pep talk is the power of one, and I'm going to use the example of my parents. My mom. So when I was 4 years old, my sister died of what we now know as SIDS. People didn't know what it was, crypt death, whatever you want to call it. And so she wanted to know why her baby died. And so back then, you could look up in the newspaper, you could find out actually people's addresses. So every day she'd look at the obits, and if there was a baby that had died that was under 6 months old, she'd call the person right up. And so she kind of, after a little while, she had a little parent group. She had this little constituency. And then my father was a legislator. So, I mean, that was one person. That was her. Okay? And then my father happened to be a state legislator. So he proposed a bill to have a controlled study, like an autopsy of every baby that fit a certain profile that was under six months or younger. And he thought he had the votes. Then he learned he was one short. This guy who he thought would vote with him. And so he went to see him, and it turned out it was a person, if I can do this, whose baby had also died. And so the guy didn't want his little girl cut up. And so the two men cried, and my father got his vote. And the study went through, and through that, they still don't know what causes SIDS, but the incidence is way down. They have a Sleep on Your Back campaign. I don't know if you've heard about that. That all arises out of Margaret Dore being upset and wanting to make a difference. And so all of you, if you can just hang on, it looks bad right now, but especially if you can get lawyers who really know statutory interpretation, because in all the Carter litigation and the litigation here in Canada, it's all about concepts. We lose on the concepts. We win when you get to the nitty-gritty and you point out to people, even people who think they're for it, what it really does. And also what I try to do is use selfish arguments. Okay, so if I'm in front of a legislature, these are typically people who are middle class and above, or they couldn't have gotten elected. They wouldn't have time to be in the legislature. So they're at least the middle class and above. They probably have a house, a car, a little money in the bank. And they're often 50, 60, 70 years old. And so I don't talk to them about vulnerable people, because that's asking them to be altruistic. I start talking to them about themselves. So I'm an elder abuse attorney. I've seen the terrible things people do at the end of life or ending lives to get the money, getting the wills changed, I've done guardianship, I've seen it all, okay? And so I start talking to them, you know, like, how much do you trust your relatives? How much do you trust your kids? This goes through. I mean, the way the bill works, the Washington-Oregon style bill works, you know, someone showed, the people that I've talked to, they sign up just in case. They're not necessarily intending to use it. It gives them comfort. That's one of Compassionate Choice's few true talking points. So people have it in the house, they feel comfortable. So once it's in the house, so say, you know, dad's, you know, got the bad news, son suggests he gets, you know, the drugs, and so they're in the house, and son's back in his life or whatever, and, you know, so dad goes to the doctor, and kind of a surprise, his test results are better. And so he comes back and tells his son, and his son's like, oh, Dad, that's great, really great. You know, because he's already been thinking about the remodel, you know, once Dad's gone. So let's drink to that. Drink number 1, 2, 3, 4. We're pretty happy now. And now a special drink. Bottoms up. And Dad's dead. The death certificate will say whatever the illness was. Good sister comes back. I can't believe he died. I thought he got that great test result. Here's the death certificate. I told you it was cancer. Or whatever it is. The perfect crime. These bills allow legal murder. They allow the perfect crime. And so all these decision makers, like the justices in the, you know, Canadian Supreme Court, the voters have naively voted this in, thinking it's voluntary, thinking that they're helping people. Oh, in Washington State it was voters. Washington State voters, Oregon voters. Sorry, I'm in so many different jurisdictions, I just, you know, I'm having a hard time just remembering, I'm not home right now. So, okay. So all of you, okay, so let's talk about Carter real fast, and I have a handout that says Carter on it that was in the pile. And, well, anyway, the thing is, Carter is based, 10 minutes? Carter's based on the right to life, all right? You already heard that? So what they did was they said that because you have to allow euthanasia, because if somebody wants to do assisted suicide, they would have to do it when they're still able to, healthy enough to kill themselves. Okay, so but that presumes that suicide is a right. There's no right to, it's been decriminalized in Canada, but it's not. I mean, if one of you right now would get out a gun and point it at your head, you know, the cops would come and take you in. Because, so anyway, it's based on a non-existent right to suicide. That's the fatal flaw of the decision. It's the linchpin of the whole decision, and it's BS. So it just seems that that would be a simple little lawsuit, and if you got a little PR going and had your stories lined up, you know, or you never know, somebody else could come into power. You never know. Like my dad, when he was a politician, he lost, he had a bad streak. He lost like 5 elections in a row. And then Attorney General he lost, Mayor Seattle he lost his Senate seat, there was another one, I don't remember. Anyway, and then his friend got elected governor and appointed him to a lower court. That kick-started his career again, and he ended up being the Chief Justice of the Washington State Supreme Court. So, you know, just because, right now you're down, but it's not over, okay? Okay, so then the next thing that's going on, well, the hospice bill, I think I'm going to skip that for the moment. So I want to talk about how to argue to win. Okay, the first thing people have to know is we're not talking about people that are necessarily dying anytime soon. If they think it's, the easy way I do that is I hold up Jeanette, my friend, This is my friend Jeanette Hall. You know, we're not talking about people who are necessarily dying anytime soon. Talked out of assisted suicide in Oregon 18 years ago. That gets their attention, okay? And then I also, for that reason, I want to be talking about live people. I do not talk about hospice. I do not talk about palliative care, because that gives the image of someone in bed, and nobody wants to vote for that, okay? So I'm saying something different than other people, and this is my experience. I've been in 20 states. I've been successful. We thought, why did we lose in Washington? Because we said, well, there's palliative care. So everybody's envisioning people in bed, and we had pictures of kind, I mean, everyone tried. I'm not blaming anybody, okay? Kind people looking down on the sick person, you know, or the elderly person in a wheelchair. No, so make them think about themselves. Well, I also tend to use green as a color. It's life, people can look at it. It's kind of hard on legislators, if you've ever been a judge or something, when you've got a whole room full of people with like red stickers. I mean, after a while, it gets everybody on edge. Okay, so the next thing they need to know is that it won't necessarily be your choice, which I guess I've already talked about, and they need to know that the bill is stacked against them. It's a recipe for abuse, it's a recipe for a lot of things, and okay, so a couple other things. Oh, the hospice bill I will talk about a little bit. It's the U.S. Congress. S693 is one version of it. That's the Senate 693. A little background on it about, I think it was in 2012, I read an article in New England Journal of Medicine, and it was a doctor writing that, you know, doctors didn't want to have to kill their patients, and so she suggested that there be something like a killing center. Okay, so this new hospice bill allows palliative care centers. And Compassionate Choices has started a new PR campaign saying that aid in dying, which is a euphemism for euthanasia, is palliative. Yeah. So it'll just, anyway, it was a unanimous vote coming out of the US Congress. It's now in committee, it's called the HELP Committee, Health, Education, something else and something else. And it hasn't moved, at least since the last time I looked. My friend and I went there and we lobbied the members, and at one office, Scott, I think it was Senator Scott, there was a young man who had really analyzed the bill. He picked up the points I'd found and more. And so I'm hoping that once they see that the bill really has problems, that won't go anywhere this year anyway. So a couple things. Also, I'm one of those people that used to read a lot of war stuff. So I read The Nazi Doctors by Robert J. Lifton, if any of you have read that. And in there's a very helpful couple of pages talking about how they convinced the German population to accept euthanasia. Okay, and I think it's very instructive so that we learn from that and we don't make those mistakes. They kept it medicalized. Always had a doctor present. So if we can help it, we shouldn't talk about it as a medical treatment unless we have to. Okay, they also talked about how expensive some people were. And they talked about people being burdens. So we don't want to use the B word and say that people are burdens or that someone called me a burden. And I know I'm going against what some of you have said today, but if you do that, all you're doing is helping the other side, okay? Because you want to get the conversation really narrow, focused on your 60-plus decision maker, that this could be you, And that'll start, because I've seen them. I mean, I stopped this bill in Connecticut just by saying something similar to that and pointing out how the death certificate would make it as a matter of law. And I saw the sponsor put his hand on his head as the bill was going down. I mean, it just was that fast. So if they know how it works, I'm not saying I always win, I make mistakes. I try to learn from my mistakes, and I do want feedback from you if there's, if I said something that was really offensive or, or whatever. You tell me privately and tell me nice, because I'm kind of sensitive, even though I act like kind of a... Okay. Oh, don't concede people are choosing. Like Brittany Menard, that's how her husband pronounces it, Brittany Menard. Did she choose assisted suicide? 2 days ahead of time, she's crying and ambivalent, right, if you watch the video. And then after the fact, excuse me, after the fact, we find out that her husband and her mother are fighting over the movie rights. Oh, it looks just like a normal inheritance contest to me. So, here's the water. Yeah, I found it. Okay. Other things, like instead of saying end of life care, ending lives. I got 5 minutes. Yeah, don't concede choice. Just really think, do I really have to, you don't have to use their narrative. The other thing is like, okay, so my dad was a trial lawyer, and you want to have your own theme of the case, okay? So if it's a murder trial, the prosecutor might say this was a murder, a heinous crime of jealousy and rage. He was already convicted once of assaulting her, she's big black eye, whatever, it was terrible. And, this time he murdered her. So if you're the defense, you want to have an actual defense that doesn't ring the bell on any of those horrible things. So you might say something like, this is a case of mistaken identity. And we're going to be, on our case today, we're going to show that he was in Canada that day. We have credit card receipts and we have eyewitness testimony putting him in Vancouver. So he wasn't in Colorado or wherever the crime occurred. It wasn't him. So you want to be like ships in the wind. So just because the other side talks about pain and suffering, we don't have to do that and shouldn't, because, unless we're forced to. So, because that's their case. Their case is suffering. And then if they do bring up suffering, there's a lot of suffering from what goes on. What I've seen a lot is with the hospice abuse cases where, one family member figures out what's going on and tries to save mom because she's not dying, and they're pumping her full of morphine. And then afterwards the family doesn't talk. It destroys families. It's not too fun for mom either. Let's see. And so don't take on a burden you don't need to prove. So you only have to prove it's a bad bill, in most of these cases in the bill situation. You don't have to prove that all these other societal things need to be addressed or anything else. You just want to focus on your narrow thing. Oh, and the Catholic argument. So I did a debate. We lost because in Washington State, one of the reasons we lost, we didn't handle the Catholic argument very well. And so it was used on me in Minnesota in a debate in a basement of a church. And so I got up and I just did my 2 points. We're talking about people who have years, decades to live, and it won't necessarily be your choice. That was it, your turn. And then she says like, well, there's something that hasn't been said here. And the role of the church and blah, blah, blah. And Catholics want to, want people to suffer, whatever. And so I just said back, a lot of Catholics here. And there might even be some cafeteria Catholics, different kinds of Catholics. But no matter who they are, how many there are, what kind they are, the bill's still going to say and do the same thing. So let's just get back to the bill. Anyway, I won that debate because I didn't take on a burden I didn't need to prove. I didn't need to justify Catholic beliefs. I didn't need to do any of that. Now, it's been also a problem for me is sometimes, I've been so in this particular debate, we made a deal with the Catholic priest that we would have a prayer at the beginning, but that they would not give the Catholic position, because that would bring in, because that would put a burden on me that I would then have to defend the church, and everything the church has ever gone wrong would then all of a sudden come back to me, excuse me. So, but some of the other churches, when I wanted to speak, they said, well, you have to talk about the Catholic position at the beginning of your thing, and I said, I can't do that, because that'll get it. That's going to make us lose, and it's been very difficult. So I don't know what the solution to that is.
You're doing it. You're keeping it legal.
Yeah, you just want to win, and then once you win, then you can take care of these other things. Let's see.
We're down to a few minutes anyway, Margaret.
Yeah, I'm just going to see if there's one thing. I guess I did it all. www.choicesolution.org. Thank you very much.
Do we have time for comments or questions? Yeah. I wonder if I could just say it.